morning. Please be seated. This is like a classroom. Everybody's in the back. Nobody wants to sit. Yes. We're here for oral argument on State of Arizona versus Asalia, Guadalupe, Alvarez-Soto. It's our number CR-24-0281. As you both know, you each have 20 minutes. There is a clock at the podium for your use. You may reserve whichever time you like for rebuttal, but you have to time yourself. So please commence.
Thank you. Good morning. I'm Jacob Lines. I'm an Assistant Attorney General representing the state in this appeal. I am going to attempt to save about 5 minutes for any rebuttal that's necessary. In this case, the state is asking this court to reaffirm two very long-held standards. The first is the standard for reasonable suspicion. The second is the standard of review. First, the standard of review that should be applied to all evidence in an appeal of this nature, and not a special standard of review for video evidence. First of all, as to reasonable suspicion, the standard has long been black letter law. In order to conduct a traffic stop, an officer needs to have reasonable, articulable suspicion, something objective, something articulable, a reason to believe that there is criminal activity afoot, or in the case of a traffic violation, that a traffic violation has been committed. In this case, that was the case. There was reasonable suspicion, and also as to the standard of review, a trial court's factual findings are reviewed for an abuse of discretion, and that should apply no matter what kind of evidence was presented to the trial court, whether it's video, whether it's documentary, whether it's testimony, or whether it's photographs.
So, well, Mr. Lines, in paragraph 12 of Sweeney, they go through the standard of review, but that last sentence, because the trial court is in no better position to evaluate the video than the appellate court, we have concluded an independent review of the video evidence. What does that mean? What does it mean to conduct an independent review of video evidence? I mean, is it de novo? What is that?
Well, that's an excellent question, and I think that's the question that several Court of Appeals judges have been asking, and some have come to different conclusions. It appears, at least in this case, it appears to me that the Court of Appeals majority in this case took that to mean something akin to de novo review, because they can just watch the video as well as anyone else. Of course, then there were other judges who have opined that that statement in Sweeney changed nothing, and others said, yes, it was different and it's wrong.
Well, should we conduct a de novo review of video evidence?
Absolutely not. There are so many reasons why not to, and I tried to touch on them in the supplemental brief. I can't say enough about the article co-authored by Judge Thumma that goes through all of these legal and policy reasons why that's simply a bad idea.
Isn't it permissible for the trial court to review the video evidence to determine whether the trial court's factual findings are reasonably supported by the evidence?
Yes, absolutely.
So did the Court of Appeals, did it create a new standard, or did it erroneously apply the standard by disregarding the inherent deference when conducting that review?
Well, that's a very good question. I think just from this case, it appears that that the majority applied a de novo kind of review, simply because of the way in which the facts, if you look in the opinion, it's sort of there was sort of a trimming away of facts. Well, this, but yeah, not really, because we're watching the video, and no, not really, because, until they finally arrive at that conclusion that, well, the only reason that the officer pulled her over was because she was passed on the right. When, of course, there was other testimony presented, but they sort of trimmed it away by watching the video.
Somewhat akin to divide and conquer analysis rejected by the Supreme Court in
Exactly.
Arvizu.
Exactly, and that's exactly what I think it was. As to the standard of review, and of course the worries that people, that can be brought up as well, what if we have a video that shows something exactly opposite to what was testified to? Well, that's fine. Under an abuse of discretion standard, that's already baked into the standard of review, because the court can look at, the court gets to look at whatever was admitted, and the reviewing court, I mean. So the appellate court gets to look at it, and they can say, this is not supported whatsoever. Where we get into problems is sort of where we see things like, and this was the case in Sweeney, well, the officer testified about the person's pulse rate, the carotid artery, visibly pulsing faster than normal. Well, we don't see that on the video. Now, I think that's a problem, because that's assuming that the video would show that. If we're going to apply a sort of de novo review, then it raises all kinds of questions. What about the quality of the video? Are we going to make a de novo review of a grainy video from a Circle K surveillance camera and
Well,
say...
Counsel, let me ask you this question then. Is there room for us to provide further guidance to a court of appeals that when you're conducting a clearly erroneous review, or even if you want to do a de novo review, you've got to articulate exactly what you think the video does and does not show, and compare and contrast that to what the trial court relied on to make its findings?
Well, I think that would be fine, and that would certainly do some good, but I think it should also be made clear that this is not de novo review. You still need to, this is either clearly erroneous or abuse of discretion, which the cases have defined as being the same. But you don't get to just say, oh, there's a video, we get to do a do-over, simply because, and I think what ultimately happens is that then you basically, I mean, we have at least a 3-tier judicial system here. I mean, if we could do de novo review.
Just pretty good?
Well, I'm thinking there's municipal courts. So I'm just starting with Superior Court. But, well, you could start with Justice Court, and there could be an appeal to Superior Court, and then a special action to the Court of Appeals, and then a petition review to this court. And if it's de novo review, you're going to have a whole bunch of fact finders, more at every level as well, looking at the same evidence. And it's just, there's so many policy reasons that it's not efficient, it's not good for the administration of justice.
I'd like to ask you about the underlying
Yes.
traffic law.
Yes.
I was unaware of this law, and I am
That makes two of us.
now aware that I may or may not be violating the law all the time when I'm driving on the highways. So.
You're not the only one.
All right. Well, that's potentially a problem. So I'm driving in the middle lane. I am going precisely the speed limit of 75. I'm passing people on the right, but people are also coming over and passing me on the right. Am I violating the law if I don't move over every single time I'm not passing a car and somebody is passing me on the right?
You know, that is such a good question, and we have gone through hypotheticals.
I need to know the
like
answer.
you wouldn't. I will tell you the answer. The answer is, well, we've got of course, the statute talks about the first requirement being, and of course, I think so many people, especially as we've talked this case to death in my office, so many people focus on the being in the right-hand lane. The prerequisite, of course, is that you're not going the normal speed, that you are proceeding at less than the normal speed of traffic at the time and place and under the conditions then existing. So if you've got people passing you and going slower than you, I think it'd be awfully hard for an officer to say, you know, if you're in between, it'd be awfully hard for an officer to say that's not the normal speed of traffic. Now, of course, there is to
that point, though, in that scenario that you just mentioned, would it be impermissible for a police officer to pull that car over, though? You know, and we also have, and I didn't see it in any of the briefing, 28-1594 that says, you know, an officer can pull somebody over and detain them to investigate an actual or suspected violation. So with that scenario that you just painted, the hypothetical, say he does pull that car over, or she does pull that car over. Is there no reasonable suspicion there? Because as we sit here, we can say, well, you know, kind of in between.
And I think the difficulty of most of the hypotheticals that we've imagined is I guess, the brevity of them. There's a lot of details that we'd have in a real case that we don't have in the hypotheticals. But I'm imagining in that hypothetical, well, it's not hard to imagine driving on the I-10 and getting passed on the right and getting passed on the left, or not, or whatever happens on the I-10. But what we're going to have to look at is, of course, start with that normal speed of traffic at that time and the circumstances. And so it's very difficult in most of these hypotheticals to say whether that would be the normal, just because I think it's very difficult without all of those other details.
Mr. Lyons, may I ask?
And that's not very helpful, but.
I'm rather wondering if such a deep dive, and the Court of Appeals did this too, on what is normal speed. And, and I don't know what normal speed is. I know what Justice Bullock's normal speed is. I've been behind him in traffic, and he does poke me along the 51. But it doesn't matter. I mean, I don't know that we need to resolve that to resolve this case. It seems to me, isn't the question under Hine, I hope I'm pronouncing it correctly, versus North Carolina, simply did the trooper have reasonable suspicion? Yes. And if the interpretation is capable of some of these scenarios that we're talking about, the way I read it, does it really matter if he was technically correct about what is a normal speed in situations that would allow him to validly get a conviction for this traffic violation? Right,
and that is a very important point, because we are looking at reasonable suspicion. And in this case, I think that there's, without even talking about a mistake of law, I think that there was definitely reasonable suspicion here because of the objective, articulable reasons that the trooper had to believe that this law was violated. The slowing down to below, less than, or as the statute says, less than the normal speed of traffic at that time and conditions. So we have, at first, this car is going the same speed as everyone else, which was about 78, and then slows down to about 70. Of course, there's plenty of evidence about whether the pacing was, whether there was pacing, whether things were calibrated right, but he says it's about 70, and everyone else is going faster. So he's got that first. He's got a reason to believe that she's going less than the normal speed.
I mean, she reacted like, frankly, I would probably react when you see a police officer behind. The first thing you do is check your speed, and you slow down to exactly the speed. Maybe a little under, just to be careful. So it certainly is, a reasonable way to react. Does that matter for as far as reasonable suspicion that a violation occurred? Does your subjective motivations of why you're slowing down, does that affect reasonable suspicion in any way?
No, I don't believe it does.
Is there a statutory exception for the officer within view of you excused to drive below the speed limit?
No, there's not.
And enforce traffic moving at the speed limit to pass on the right?
No, there's not. And there is simply, I think one of the reasons that this is such I guess we get excited about this is that we all drive, and that we all know that, a lot of the traffic laws that exist are, as Hamlet says, observed more in the breach than the observance. But what we have here is not only the slowing down, but then the staying in the middle lane. And of course, there was a lot of talk at the Court of Appeals about, well, she couldn't get over into the right lane. And of course, I think the record belies that assumption, because there certainly was the time, and the trooper testified about that he waited until that car had finished passing her on the right, waited to see if she was going to get over, and then when she didn't, then he activated his lights. So yes, there are all of those concerns, simply because we know our natural reactions.
And can I ask you, we alluded to, Justice Montgomery alluded to ARS 28-1594 in the hypothetical context, and obviously we talked about the reasonable suspicion standard, but ARS 28-1594 allows a police officer to make a stop and detain a person as is reasonably necessary to investigate an actual or suspected violation of this title. What relevance or what weight do we give to that statute?
I'm not sure how much we need to look at that. That seems to me to be more of an authorization than, I mean, it certainly doesn't answer the constitutional questions of reasonable suspicion. But I think certainly the officer is authorized to do that. That's part of their job duties. I think that was more of what that statute's about.
A last question from me before you sit down for a moment. Illinois versus Gates instructs us that we view reasonable suspicion based on, and here I'm quoting, factual and practical considerations of everyday life on which reasonable and prudent people, not legal technicians, not legal technicians act. So the slowing down when you see a police officer behind you, that sort of thing. Is that the applicable standard?
Well, we certainly do need to look at it as a normal person does, not like a legal technician. And I really think that's really where I find a lot of fault with the Court of Appeals majority, in that it took a lot of technical legal steps to get to where they got, to then decide, okay, even with all this stuff, there's not reasonable suspicion. We're going to narrow it down to this statutory question about whether you violate the statute simply by being passed on the right, which isn't the question. The question is reasonable suspicion. There are, objective articulable reasons to think that this person violated the statute.
I have a quick question going back to section 28-721B. Really, it's not a matter of whatever the actual speed that she was driving. And the hypothetical that was mentioned at the very start of this exercise, the question was whether if the person is driving at the actual speed limit, excuse me. So if someone's driving at the speed limit, it's in relation to their driving it's in relation to other drivers,
yes.
right? What everybody's sort of pacing. And if you start to fall behind, even if they're slightly speeding, if you're going 75 and everybody's going 78, then you can go 75 on the right? That would be the normal, as to the normal speed of traffic.
Yes.
Would that be right?
I believe so, yes.
Okay.
And I'll try to keep the last 2.5 minutes. Thank you.
Thank you. Okay, is it Ms. Gordon-Panuco? I got that right.
Good morning. I am Rosemary Gordon-Panuco, appearing on behalf of Asalia Alvarez-Soto. With me is Seth Apfel from the AACJ, and I'd like to reserve 5 minutes for his argument at this particular point in time. I have to, Justice Bullock, I was driving up here, and every time I've driven to Phoenix since I've had this case, I think of the same thing, and I'm driving and I'm thinking, and I'm driving a Volkswagen, one of the trooper's target vehicles too, and I keep thinking, am I going to get pulled over for staying in the center lane and at or around that? I think that you've asked some very good questions with regard to this, but at the end of the day, I think that the Court of Appeals got the result right in this particular case.
Ms. Gordon, let me ask you something, because I'm concerned about the application of Sweeney and this independent review. Is that something that should be limited only to video evidence, and why not apply it then to photographic and other tangible evidence?
What's interesting is much like Mr. Lyons did, I did quite a survey of state courts, and that independent review, I think, has some, and it was actually a Florida case that really put me onto this, was that there is still some deference left in the independent review, and that's going to go to the quality of the video and things like that. that it's not strictly a de novo review. That independent review means that there is some deference that's going there. But it is and I think with the increasing use of video, which is getting just plain nuts, if getting some of these cases coming through for the Court of Appeals and things like that, it's a question that I don't think has a really good answer. It's something that this August court is going to have to figure out. I think that perhaps it depends. I've seen so many different cases, one of which where they had, where the question was, did the officer actually see the violation? And when they looked at the video, his police car was in a position where he couldn't have seen whether that guy went over the road.
Right, so in that scenario, you have the court looking at video
Right.
to see whether there's a reasonable interpretation, or whether the trial court's interpretation is
Right.
reasonable, right? So if the
Right.
testimony is that, let's say, a suspect was wearing a red hat, and there's video, and the trial court says it was blue, then that would not have been consistent with the evidence. That wouldn't be reasonable. But that review of the video is different than sort of saying we're going to independently, and you're telling me that there's some deference to the trial court, but I'm not seeing where that language is in Sweeney. And independent means apart from what the trial court did, right?
I think part of the problem in this case, well, the big problem in this case is there's no findings of fact with regard to the stop. So what is there to give deference to? And that's also a trend that I saw in the other states' cases, is they seem to give more of an independent review to video when the trial court says nothing about the facts. And so you're left with this void that, okay, they make this decision, they deny the motion to suppress, and all they say about the stop was it was justified.
So back to my question, if we should continue down the line that Sweeney started, why should we limit it to video and not photographs and other tangible evidence?
I think that it shouldn't be limited to video. I think that was the context in which they made that that they basically were telling everyone, well, this is how we looked at it. That was in the context of a video. I think it could be expanded to photographs and documentary evidence. Again, as long as it's reliable. I mean, you've got all these other things.
So then your position is that the appellate court should conduct an independent review and just take a look at it fresh, regardless of what the trial court did.
And then apply it to what the trial court did.
And then my second question, and I promise I'll let you continue with your presentation, is then should we engage in an independent review of the video? The Court of Appeals is an appellate court, and we are as well. So should we conduct an independent review?
I would ask you to, yes.
Okay.
In this particular case. I mean, given that we've got no trial court findings.
Okay.
And so I think if you wanted to limit it, you have to start looking at, well, if there's no findings, what's this court supposed to do? You're supposed to look at all of the evidence and the totality of the circumstances. How can this court, if the trial court makes no findings on that video or no findings whatsoever, how can you just say, well, I'm going to just shut my eyes to that? That's crazy. That's not going to happen.
Okay.
But in any event, getting back to 721B, what's interesting about that statute is that it's not just the normal speed of traffic, it's also in the time and place and the conditions. And that's something that's important. So the legislature has made room for people to adjust themselves in traffic. That's the thing that probably makes me the craziest about this, is that watching this, and even listening to his testimony, she's moving along, and then he comes up on her, and notice there's no brake lights. And he doesn't say that he saw any brake lights. She slows down, but did she take her foot off the pedal? Did she drop her drink? I mean, who knows the why? And nobody drives perfectly. I think Justice Bowen's got this same concern I do driving on I-10.
It was clearly an admission on the record.
I'm not perfect either in my driving. And to take this statute and say that's a violation, and it's a momentary slowdown, she picks back up.
But is this case about proving the traffic violation? I read this case as a very thorough and spirited consideration of whether there was an actual provable traffic violation. How is that the standard under reasonable suspicion? Because it seems that the court just jettisoned the reasonable suspicion inquiry in favor of a traffic violation case.
Well, what they did is they're trying to explain why there is no reasonable suspicion. And there's no reasonable suspicion because there's no traffic violation here.
And to that point, though, there doesn't have to be an actual violation. It just has to be one that's suspected that the trooper can reasonably articulate why he thought there was a violation. I guess that's the struggle I'm having with how the Court of Appeals addressed this in their entire statutory interpretation, is in most of the briefing here, too, about focusing on whether or not there in fact was a violation. If you had to prove the violation in the first place, we're not dealing with reasonable suspicion, then we're dealing with probable cause. Where am I wrong on that? I'm sure you can find a place.
Giving me a second to think here. Thinking about that, if they don't have to have, if there's not a traffic violation, then you're just pulling people over for whatever.
Or suspected.
And even that language in that statute that you were quoting, and I have to confess I didn't figure that one out and didn't see it. Perhaps Mr. Lyons didn't see it either, I suspect. Anyhow, how does that square with the Constitution where you have to have reasonable suspicion? I mean, that pretty much authorizes, you can stop anybody for anything and say, oh, I suspect this.
Well,
there's momentary slowdown, you're suspecting that.
I'm sorry to interrupt, but I have to get a word in here. How do you do it? I asked about Mr. Lyons about the Hine case, the North Carolina case, and that does give some boundaries to what you're talking about. It says that the trooper could be reasonably mistaken about the law and still have reasonable suspicion that it was violated. And when I read the Court of Appeals decision, I didn't see anything that suggested or even addressed that the trooper's belief was an unreasonable interpretation of the law. Did I miss something in that decision? And is that necessary for us to address that issue of was the trooper unreasonable in his view of what the law required?
I actually agree with you. And my position is it was an unreasonable interpretation of that law. It was any excuse to pull her over, to be very blunt about this. That was something Judge Starring at oral argument said, well, the bottom line is he was going to pull her over no matter what.
Is a pretextual stop unconstitutional? If the law enforcement officer can articulate a reasonable suspicion of a traffic violation? The motive doesn't matter, does it?
Right, exactly. But he was going to find a traffic violation no matter what. And that's what he honed in on was she wasn't really speeding because with the traffic, so he hones in on 721B as, oh, she momentarily slowed down there. And then, but what's interesting, she speeds right back up. So is that enough for a suspected violation of this statute, given the time and place and the way the traffic's flowing? I mean, this is what kind of bothers me, is that you're pretty much saying that, well, the driver has to drive perfectly or else I'm going to get to pull you over for this. And that's what makes me nervous about saying that the stop here was constitutionally valid.
So then,
because it just is based on such a momentary thing.
Getting back to the Sweeney question, Justice Timmer is focused on Hines and I'm focused on Sweeney. Did Sweeney change the standard? Is it no longer abuse of discretion when it comes at least to video?
The standard
of review for the appellate court and looking at how the trial court looked at the evidence. Is the question whether the trial court abused its discretion in the way that it assessed the video?
Well, you have so many different standards of review. You're reviewing the factual findings, there's the abuse of discretion, then there's the mixed question of fact and law, which is de novo, including the ultimate decision of the trial court whether they found a constitutional violation or not. So with this kind of mix of standards, it's difficult for me to sort of parse out where is that independent review. It's more related just to the evidence as opposed to the entire decision here, which ultimately is, did the trial court make a mistake by denying the motion to suppress? I don't have a good answer for you on that. I struggled with that myself, very much so.
And so, because I'm thinking if we happen to not all agree, all 7 of us, on what the video evidence shows, then wouldn't we be able to say from there that reasonable minds can differ and therefore it was not an abuse of discretion? on the part of the trial court?
I would ask that you not do that. But
I'm sure you would.
especially when you have no fact findings whatsoever from the trial court. I think it's real difficult to do that when you're looking at a trial court and just basically blew it all off. And
But we can look at the record.
yes, you can look at the record and the totality of the circumstances. And I think that that's what gets you there. Exactly what independent review means, I don't even necessarily know the Sweeney Court knew that. They just wanted to be able to look at that and not have to give great deference to the trial court's findings because they found, wait a minute, this is different. And that's a struggle. This is not just a struggle in the state of Arizona. This is something that you'll pick up in a whole, I mean, between Mr. Lyons and myself, lots of different cases. I even went beyond that, even my home state of Michigan, they're struggling with this. Not in front of the Supreme Court yet. But it's something that this is a standard. What are we going to do with all this video evidence?
But Justice Cruz brought up a good point in her earlier questions about photographs. I mean, is it, I know video's out there now, it's new, it's everywhere, but is it really any different than the standards we apply to looking at photographs? I'm thinking in particular, because we unfortunately see them all the time, gruesome photographs. And you might have the issue might be, should the trial court have allowed the jury to see this very graphic image? Was it too inflammatory? And we look at it, but I think we still, it's an abuse of discretion standard. It's not a de novo standard, is it?
No, I mean,
so why would it be any different then? It's like, well, we might have made a different call. I looked at that video in this case, I might have made a different call. But under abuse of discretion, it's enough to support it. Same with graphic photos all the time. I might not let the jury see this, but can I really say that the trial court was wrong to not allow it in? No.
That's to the point, and that's where sometimes, to a certain extent, that's a different question about that photograph. This is actually the events that are in question. Is this a valid traffic stop? The video is of that, as opposed to the after. Here's the dead body, and yes, it's eviscerated, and he's chewing on the bowels. I mean, sorry, I'm getting really
Counsel,
graphic.
but let me ask you a question to follow up on that particular point. Is it really that different, though? Because if a photo is going to be admitted, typically a foundation has to be made.
Right.
There may be additional testimony to put more in the record on angle, lighting, time of day. And same thing sort of with video, too.
Yeah.
That video evidence itself may not tell you everything. Even with an officer's body-worn camera, you only get to see what that camera sees. And there may be something going on in the periphery. And body-worn cameras don't start collecting audio until they've been on for about 30 seconds. Mm-hmm. So there's a lot of things that could be happening that aren't going to be evident unless and until the court of record hears testimony that goes along with it. And I'm going along on this point because I want to ask you this question. If we were to go along with Sweeney, if we were to accept the invitation to do de novo review for this type of evidence, even audible evidence, then aren't we asking every single time any of this evidence is introduced in a case for appellate de novo review on it? I'm worried about then there being an equally expansive number of cases filed on appeal just to see if somebody else might disagree with the trial court.
I don't think that necessarily is something that's going to happen, but second of all, I understand the concern. You don't want the appellate court being the second fact finder, basically, on things like that. However, you also don't want to give such complete deference to trial courts that when you see a clear error or when the evidence is just, you're looking at the totality of the evidence, the testimony and the video and the pictures and whatever, and you're saying,
But isn't that what an appellate court does right now and with the current standards of review?
I think that if you come out and declare a complete deference, that you're going to see appellate courts not having the courage, I hate to say that, but I'm going to say it anyway, to reverse trial courts on some of this stuff. When it's not a credibility issue, it is more of a technical issue in something like this. So I think that, yes, to a certain extent, the standards review do help it, but not entirely.
So let me follow up with that, but either of you can answer this if you want to hand the ball over. I'm keeping an eye on the clock a little. I think Justice Montgomery's point, at least for me, goes to the question of a contextual review by the Court of Appeals. That seems very concerning to me if we're looking at a snippet of evidence afresh, not using de novo or anything like that. We don't have the context that the trial court did.
And I understand that question, and I think that it really doesn't matter what this court wants to call it. I think one thing to consider is that in circumstances like this, where number one, you have no factual findings, and more importantly, where both parties are in agreement that the video is the most reliable evidence. There's no question as to authenticity. Everybody agrees that the video depicts the offense, or the alleged offense as far as the traffic violation, that may be a carve-out. And that seems to be a trend among states. Several states are going in that direction, Georgia, Texas, that when that narrow set of circumstances exists, that maybe we can scrutinize the video a little bit more closely. You can call it whatever you want to call it, but that just may be a little bit of an exceptional circumstance.
But we scrutinize it to measure the decision that's already been made.
Yes, I mean, certainly you can take that into account. In this circumstance,
we don't just take into account the decision of the trial court. We're here to review and determine whether it was an abuse, whether the conclusion of the trial court was just far-fetched.
Correct, and I don't know if you want to call it a heightened abuse of discretion, but if it encourages trial courts to actually explain their decisions, that's a good thing.
So would you like us to vacate the Court of Appeals opinion and remand for the trial court to enter findings of fact?
No, because in this case, they would have been correct even on an abuse of discretion standard. And I did want to circle back to a question that was asked by several justices about, particularly Justice Timmer, about whether or not it even matters whether there was actually a violation. And I think that an important point here is that the record in this case would seem to indicate that the trooper did not have a good faith basis. There was no mistake of law. He actually said during the evidentiary hearing, I study the law. I'm familiar with it. He cited to Sweeney. He talked about how they're taught on this. There were 3 prior cases where similar stops had been held to be impermissible in the federal court, all involving DPS. So I think the record in this case indicates there was no reasonable mistake of law under Hine.
Did the Court of Appeals make a determination on that? I didn't see it in their opinion.
No, but that's what the record indicates, and I think that one of the things that everybody seems to have missed is that the trooper himself, during the evidentiary hearing, when he was talking about the vehicle on the right passing, says the phrase that the vehicle on the right pumped away. That doesn't imply that the defendant slowed down. That implies the car on the right sped up. And I think that was very, very revealing. And the last point that I want to make is Justices King and Montgomery both asked about ARS 28-1594. And I just want to point out that irrespective of what that statute says, the Fourth Amendment controls here. The statute can't trump the Fourth Amendment, and that's really what we're looking at.
Right, and to that particular point, no, it doesn't, but that's sort of guidance for law enforcement that if they see an actual or suspected violation, they can pull somebody over. And that actual or suspected part of it, I guess my point in raising that actual or suspected, that seems to me to be almost a codification of reasonable suspicion.
It does, but in this case, there was no suspected violation. There was, I'm going to follow this person, and I'm going to try to find a reason to pull them over, even though I know what the law says, and the law would seem to indicate that this probably isn't a valid stop. And that seems to be what the record indicates in this case. And thank you, Your Honors.
Thank you very much, Mr. Appel. Mr. Lyons.
Well, I'd like to give the trooper a little credit here. I don't know him and I've never met him, but I appreciate his openness in the evidentiary hearing. He was very open about, yes, he wanted to pull this vehicle over. He explained why he had this, I guess, hunch, but also the reasons why. But then there's also something, and I'll direct you to pages 12 and 13 in the evidentiary hearing transcript. He's asked, now, you decided to pull this car over. Yep, I decided to follow the car and see if she committed a traffic violation. And he says, are there cases where you have an interest in a vehicle, you decide that you want to try to make a traffic stop, and you're not able to do so? Yes, sir, there are. So he says, yeah, there are times when I'm not able to do so. And then continues, why would you not be able to do so? And he says, well, I got a camera on my vehicle. Everyone can see my stops. And I'm not going to pull someone over if I pull someone over for no violation. So I know that that doesn't mean that he's perfect, but I would like to, sort of acknowledge that this trooper was not saying, I'm going to pull him over come hell or high water. The trooper was saying, I'm going to see if there's a constitutional reason I can pull him over. And I think here, one of the important points to reiterate, which has been reiterated by several times, is just that this is about reasonable suspicion. Did the trooper have objective, articulable reasons to think that this statute was violated? And I think that the record shows that there is. As for independent review, there's I have to think of one good thing to say about independent review is if this court does establish a new standard of review, there will be a lot of new work for appellate judges and lawyers and lots of things for clerks to discuss over lunch. What standard of review applies to this piece of evidence? How about Exhibit 17? Well, that's going to be independent review.
Well,
How
what
about Exhibit 18? Abuse of discretion.
Yeah. What about the suggestion, though, that this is a carve-out where we don't have factual findings below, and this is the evidence, the video evidence, as suggested by your opposing counsel?
Well, I think that really would create kind of an arbitrary carve-out, because I think those who have practiced a lot in Superior Court and those who have been Superior Court judges know that you don't always make findings of fact. You've got a lot of motions. And here the judge says, okay, I find the stop was justified, and then goes on to the next issue, which was the delay. I'm out of time.
Thank you, Mr. Lyons.
Thank you.
Thank all counsel for their arguments and their briefing on this matter. We'll take the matter under advisement and issue an opinion in due course. We're going to recess to allow a change on the bench.